The broadcast is now starting. All attendees are in listen-only mode.
Hello, this is Jennifer Schaus, and thanks to everybody for joining us today in our Government Contracting Webinar Series. We are in week number 8 of 10 weeks of Government Contracting Webinars every day of the business week. The full list of webinars can be found on our website under the Webinar section. All of the recordings are typically posted the same day in the afternoon below the schedule, and they are all segmented by topic. A little bit about us is on this slide. Our services range from anything for government contractors, ranging from 8A certification, contract compliance, GSA schedule assistance, and other services. We do host networking events and seminars throughout the year. You can find those on our events page, but a more current list would be found in our newsletter. You can sign up for that on our website as well. My background is listed on this page, but more importantly, I'd rather dig into our topic today, which is ITAR, and Tom McVeigh from Williams Mullen is kind enough to join us and share his knowledge and expertise. Tom, thanks so much for joining us today. I'll hand the floor over to you.
All right. Thank you, Jennifer. Good afternoon, ladies and gentlemen. Thank you and welcome to our program, ITAR for Government Contractors. I'm Tom McVeigh with the law firm of Williams Mullen here in Washington, D.C. Jennifer, this webinar series is fantastic, so I'm pleased to be involved in that. All right. Today, we're going to talk about ITAR. Many of you have been hearing that you may be subject to these requirements. Your prime contractors may be requiring you to register with the State Department under ITAR. These DFAR clauses, such as 225-7048, may be showing up in your contracts. These are other clauses, but you're not sure if this applies to you or if it does what you're supposed to do. And that's what we're going to discuss today. ITAR can be a little confusing, but I have a process. I've identified a number of cornerstone concepts here. If you understand the cornerstone concepts, then all the other pieces fall into place. So if you just give me 20 minutes, you'll know everything that you're going to need to know in this area. Unfortunately, there's not going to be time for questions, but if you have questions, you can send me an email. You'll see my email address, and we will also be sending, we will also have handouts available as well. All right, let's jump right in. ITAR stands for International Traffic in Arms Regulations. It's administered by the Directorate of Defense Trade Controls at the State Department. This would be the next slide, please. The Department of Defense is also heavily involved. It's the Defense Technology Security Administration. So if you send a case into the State Department, they'll almost immediately send it over to the DoD. And this basically is the U.S. government's regulation of the defense industry. Next slide, please. So the first cornerstone concept is ITAR contains a list of products. It's called the U.S. munitions list. And if your product is on the list, you're subject to these controls. This is a key concept here. If the product is on the list, everything else flows from that. So next slide. So these controls apply not just to physical products, but also to software and technical data as well. So if there's a product on the list, let's say it's a navigational device, software that runs the product is also on the list. And technical data regarding the item is also on the list. Technical data, drawings, algorithms, manuals, any information on the design, manufacture, or use of the item. Next slide, please. So if the item's on the list, the electronic files are on the list, the specification sheets, the technical manuals, etc. Okay. So how does one export software and technical data? Well, the State Department has a very broad definition. Next slide, please. Very broad definition of how you export these items. If you send it abroad, if you take the disk or the manual and put it in the FedEx envelope and ship it over to London, that's the export of technical data. If you go abroad and release it, if you give a presentation at a business conference in the UK or a private business meeting with a foreign national overseas, that's the export of technical data. Electronic communications with foreign nationals, sending an email or a fax or a phone call with a foreign national is the export of technical data. And what a lot of people, what confuses a lot of people, if the foreign national comes to the US and has access to the technical data here, it's considered an export as well. That's called the deemed export rule. There was a case in California called the Suntech microwave case. That was the first criminal indictment and conviction under the deemed export rule, disclosing technical data about a controlled item to a foreign national in the U.S. And by the way, what exactly is a foreign national? If a foreign person is here and they have permanent resident alien status, if they have a green card, they're treated as if they're a U.S. citizen for purposes of the export law. If they don't have a green card, if they're here on a visa, they're treated as a foreign person, an H-1B visa, business visa, student visa, etc. All right. Another cornerstone concept, these controls also apply to services. So if there's an item on the list, let's stick with our example of the navigational device, performing services for foreign parties related to that item is also on the list. Installation services, troubleshooting services, warranty repair services. If you're performing these services for foreign parties, it's on the list and it's subject to these controls. Engineering services, retrofitting, consulting services, etc. Here's some examples of USML items: electronics, drone aircraft, command, control, and communication systems. This is the next slide. Flight control systems. These are just examples. This, of course, is not the complete list. These are just some examples. Often intelligence and security services are on the list. Another big area, if you could advance the slide, is parts and components. So often, if an item is on the munitions list, parts and components that are specially designed to be used in that item are also on the munitions list and subject to these controls. In certain instances, they may be on a companion list called the Commerce Control List under the Export Administration Regulations. Under some recent amendments to the law, some of the items were moved from ITAR control over to EAR control, and I'll be talking about that in a minute. But the bottom line on the parts and components, if they're specially designed, they will be controlled either under ITAR or EAR. The list that I showed you in the beginning of the 21 categories of the USML, that's a little misleading. That's just the table of contents. Those are just the names of the end items. But the list also includes these subsystems and parts and components. So category 6, for example, is naval vessels. And of course, a naval vessel, like a submarine, is on the munitions list. But also under category 6, you'll see a lot, or elsewhere on the list, you'll see a lot of the electronics, communications gear, navigation systems, the computer systems and the software, the high performance materials, etc. Those often are controlled as well. All right. Another area that's important is services. I mentioned previously that if you perform a service related to an item on the USML, that service is controlled. There's also some services, even if they're unrelated to USML items. So as I mentioned, in certain cases, performing intelligence services or security services are regulated. Providing military training for foreign parties is covered. Providing military advice to foreign parties is covered. We have a lot of clients that come to us and say, we were hired by the U.S. Army to put on training for the defense forces from the Czech Republic or from the United Kingdom. Even though the U.S. Army is going to pay for it, they're performing the service for the foreign party that's regulated under ITAR and requires a TAA, a Technical Assistance Agreement. All right, next slide, please. A key question that the State Department will ask and the DoD will ask when trying to decide if an item is on the list is was it developed with military funding, DoD SBIR contracts or research grants. If it was, there's a high likelihood it will be controlled. Not 100% certain, not everything would be controlled, but there's an increased likelihood that it will be controlled. All right, next slide, please. So what happens if your item is on the list? All right, so up to now we're talking about, am I on the list or not? Well, if an item is controlled, there's a number of major requirements that I'll mention. The first is for physical products, if you wish to export the item, you're required to obtain an export license from the State Department unless an exemption applies. For software and technical data, you're not permitted to send it abroad without a license or disclose it to a foreign national in the U.S. without a license. So you can't send it abroad or take it abroad unless you get a license. Next slide, please. For services, you're not permitted to perform defense services for foreign parties outside the U.S. or for foreign parties within the U.S. unless you get a license. The license for services is called Technical Assistance Agreement, or TAA. So how do you perform a service for a foreign party in the U.S.? A phone call. If a company overseas calls you up, they ask you to serve as a consultant on integrating certain defense items into their system, and you're giving them advice over the phone or sending them emails or Skyping. That's the performance of a defense service, even though you haven't left the United States. Also, certain imports, temporary imports, require a license. We're not going to have enough time to go into that in detail, but that should be on your checklist as well. Another big area is registration. This is the next slide. Companies that manufacture or export or temporarily import USML items or perform defense services are required to register with the State Department. So there's a lot of discussion these days. Prime contractors are requiring their subs to register, and a lot of people are saying, am I required to register? Now it's important to note, a lot of people used to think that you only had to register if you were exporting. But that's not correct. The registration requirement applies even if you're simply manufacturing a defense article or producing a defense article wholly in the United States and there's no exports. So the registration requirement applies to many defense contractors, even if they have no international business. In addition, there are some data security requirements under DFAR 2047012. There is security controls for data networks. Contractors, we recommend that you look in your contracts to see what specific controls apply. Under 7012, the security standard that's adopted is NIST SP 800-171, as set out in the slide here. Under this reg, contractors required who have covered defense information are required to have these controls in place by December 31 of this year. So that's a big deadline coming up for contractors. Some other requirements related to this: there's a cyber incident reporting requirement. Also, there's controls if contractors want to store technical data in the cloud. There's restrictions on that, and this is a mandatory flow down to your subcontractors, so you're required to make your subs comply with this as well. All right. There's some other ITAR requirements. We're not going to have time to go into all of these, but if you have questions about these are also very important. If you have questions, just shoot me an email and we can provide additional information. So the bottom line here is if you're doing almost any kind of work in the defense area, selling products, preparing technical analyses, studies, reports, writing software, doing consulting, if you're a prime or a sub, products or services, you probably will be controlled under ITAR under one scenario or another. All right, another important piece here, what happens if something goes wrong? So this is the next slide. These are, one more slide, please. These are criminal statutes. There are civil and criminal penalties for ITAR violations. The most severe criminal penalties are up to $1 million financial fine and or 20 years in prison. So these are criminal statutes. The State Department and the U.S. Attorney and the Justice Department will prosecute the company as well as individual officers, directors, and employees in their personal capacities. There are other penalties available in addition, including debarment and denial of export privileges, and debarment itself is a very significant penalty, sometimes the worst penalty of all. This is a list of some of the recent cases, enforcement cases. There's actually a case that just came out last week called the Bright Light case. This is the next slide, please. And this was an enforcement case against a small government contractor making replacement parts for military equipment. And the opinion goes into great detail about how even smaller companies are subject to these requirements. So you don't get a free pass if you're a small company. Next slide, please. Another penalty, if you would, or another thing that happens if there's a violation, the agencies will put a press release up on the internet. It'll announce the violation. It'll announce your company and the violation. And so this can, if someone Googles your company's name, this thing pops up. And now your customers will see this, your employees will see this, your competitors will see this. This could be among the most severe problems that arise out of a violation as well. So it's certainly worth paying attention to these things. Okay, so let's say you are controlled under the regs. What's your strategy for complying with them? Well, we have a three-pronged recommendation: classification, application, compliance program. Classification simply means you need to review the U.S. munitions list and see if your products or the services that you perform are on the list. Remember in the beginning we said if your products or services are on the list, you're subject to these controls. Well, unless you go down the list, you're never going to know. So this is really the critical first step. All right. Second strategy, application. Application simply means if you need a license for something to export a product or perform a defense service, apply for it. And usually the Department of State will grant these authorizations. Many people think that, oh, if something's ITAR controlled, I'll never be able to do any overseas activity at all. And that's not correct. Most of these activities probably can be performed. You can do work overseas. You can do work for foreign customers. You can do work for the U.S. government overseas. You just need to follow the ITAR requirements, and either apply for licenses or work under applicable exemptions. The last strategy is compliance program. This is a new slide, please. A compliance program is a management system within your company for complying with the law. You have all taken the time to sit through this webinar and learn these issues. So you now understand this, but how do you get everyone else in your company to learn as well and to have compliance throughout the company? And that's what the compliance program is. We do a lot of work with companies in this area. We prepare these compliance programs for companies, and we do that on a regular basis. So part of this is we recommend that the company appoint a person within the company to be in charge of ITAR compliance, the compliance manager. It doesn't have to be a full-time job. There can be other duties that the employee has as well, but it's that person's job to oversee this within the company. And then there are policies and procedures that are adopted. You conduct training for your employees, and you set up a system to comply with the ITAR record-keeping requirements. So, as I mentioned, we do a lot of work with clients preparing these compliance programs. We prepare the policies and procedures. We educate the compliance manager, and we do the training for the employees. So this is an important part of the puzzle here. All right, next slide. We're not going to have time to go into detail, but I just wanted to mention there have been some recent amendments under the ITAR, and a number of items that were previously regulated under ITAR were transferred to be regulated by the Commerce Department under the Export Administration regulations. I will tell you the requirements under the EAR are very, very similar to the requirements under ITAR. They're a little different, but they're similar. So if you've heard that maybe one of your products is no longer ITAR controlled, but is controlled under the EAR, you need to recognize there are still very significant controls, and you need to be mindful of these as well. All right, I think we're getting to the end. I'll just mention a quick word about our firm, Williams Mullen. Williams Mullen is a law firm. We help companies in this area. We help you classify your products and determine if your products are on the munitions list and the commerce control list, identify what legal requirements may apply to your company. As a result, we assist in filing license applications, TAAs, compliance programs, etc. So we're here to help you at whatever level you require and what you're doing. All right.
Great. Thanks.
Good.
Thanks, Tom, for a great presentation on the ITAR. Thanks, everybody who joined us today. Tomorrow, we're covering the European Union's GDPR and the data privacy requirements for U.S. government contractors. Friday, we get into the management section of the proposal. Week 9 and week 10, which will be the final weeks in the series, we cover sole source contracts, 8A certification, and GSA schedules. The full schedule can be found on our website under the webinar section. Thanks again, Tom, and please reach out to Tom if you want the additional handouts that he has on this topic. You've got his contact information there, and we look forward to seeing you next time.
Thank you.